Welcome, everyone. My name is Grant Huscroft, and it's my pleasure to welcome you tonight to the second annual Coxford Lecture and to introduce tonight's speaker. I want to say briefly about the Coxford Lecture. This series, we're into our second lecture now. It was endowed by a generous gift from Stephen Coxford, who's a Western law graduate from 1977. And the purpose of the Coxford Lecture is to advance the rule of law and public law scholarship in general. We are very, very grateful to Stephen Coxford for his support of public law. I'm very excited for the opportunity it presents to bring in leading public law scholars to Western. The Coxford Lecture is now Western law's most prestigious lecture series, and its stature will only grow in the years ahead. Tonight, it is our privilege to have Professor Jeremy Waldron with us. Professor Waldron holds the rank of University Professor at New York University. He is a graduate of the Universities of Otago in New Zealand and Oxford University in law and philosophy. He has taught law, philosophy, political theory, and has written extensively in all of these areas. He is one of the world's preeminent theorists on rights, constitutionalism, democracy, judicial review, property, among other things. And his resume speaks for itself. He has held appointments at Columbia, Princeton, Berkeley, Edinburgh, and Oxford. He has delivered some of the most prestigious lectures in the common law world, including the Seeley Lectures at Cambridge, the Carlisle Lectures at Oxford, the Wesson Lectures at Stanford, the Storr Lectures at Yale. He is, in short, a scholar of enormous stature. And what's more, he's one of New Zealand's finest exports to boot. My pleasure to welcome Jeremy tonight to deliver the 2009 Coxford Lecture, Cruel, Inhuman, and Degrading Treatment, the Words Themselves. Ladies and gentlemen, please join me in welcoming Jeremy Waldron.
Thank you, Grant. Thank you for the invitation. It's an honor to be here to deliver the Stephen Coxford Lecture for 2009. That was a little bit loud, so. Now, as Grant said, my topic this evening is cruel, inhuman, and degrading treatment, which, as you know, is language used in the International Covenant of Civil and Political Rights and used in a great many other national and international instruments. And I want to take the opportunity to talk not just about how to parse this standard, but to reflect a little bit on how to parse standards of this general kind, because it is quite common in human rights law and international humanitarian law to use not just clear operationalized rules, but provisions that require us to think through complicated value judgments. And what I want to do tonight is to illustrate jurisprudentially how to think through complicated value judgments when the law requires us to make them, and to think about that not just in the abstract, as legal philosophers sometimes want to do, but to think instead about it with regard to a particular detailed case that we can consider. So, we have, let me use this PowerPoint. We have, as I said, in the International Covenant on Civil and Political Rights, in Article 7, a provision that nobody shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. A great many national and regional bills of rights say something similar. One of the best known is the European Convention on Human Rights, which, notice how it omits the term cruel, but says no one shall be subjected to torture or to inhuman or degrading treatment and punishment. And really it's the inhuman and degrading provisions that I'm going to concentrate on this evening. There are similar provisions in national constitutions. In the South African Constitution, not to be treated or punished in a cruel, inhuman, or degrading way. In the New Zealand Bill of Rights Act, everyone has the right not to be subjected to torture or to cruel, degrading, or disproportionately severe treatment or punishment. A little bit later I'm going to talk about another provision in the New Zealand Bill of Rights Act which, which talks about the specific position of somebody who's been deprived of their liberty and is in prison or in some other form of incarceration. And there is an additional requirement that they shall be treated with humanity. And we want to talk about the relationship between that standard and these standards here. And you find it, as I want to indicate, all over the world in bills of rights and constitutional documents. The Canadian Charter, as you will know, uses the older language of cruel and unusual treatment or punishment. That's old language taken originally from the English Bill of Rights of 1689. Excessive bail ought not to be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. This was part of the provisions laid down at the time of the settlement after the Glorious Revolution in 1689. It was adopted, as you know, more or less word for word in the American Constitution, in the Bill of Rights, adopted in many of the American state constitutions, Texas, for example, in 1876, and 100 years later in Canada, where you have the same language of cruel and unusual treatment and punishment. So there's an interesting story to be told about how we moved from a focus on cruel and unusual as a standard boilerplated language in these matters and began boilerplating instead the language of inhuman and degrading, sometimes with an overlap to cruelty, sometimes to something beyond cruelty. In addition to these general provisions, you find similar language used in some more specific international instruments. The Convention Against Torture, for example, includes a provision dealing with inhuman and degrading treatment. The Rome Statute of the International Criminal Court has similar prohibitions, and best known, Common Article 3 of the Geneva Conventions has some similar language. Notice there that people who have laid down their arms or are otherwise hors de combat shall in all circumstances be treated humanely, and the following things shall be forbidden: cruel treatment and torture, outrages upon personal dignity, and in particular humiliating and degrading treatment. So again, the language is not exactly the same, but it's using some of the same ideas. I used to think, when I did some work on torture during the dark days in the United States from 2002 to 2008, I used to think that the best way to think about these formulations, inhuman and degrading treatment, was that they erected a kind of cordon sanitaire around the central provision on torture. We had a central provision prohibiting torture, and in order to make sure that people wouldn't, as it were, push the envelope of torture, we built a fence around the norm, or laid a minefield around the norm to stop people even approaching the envelope of torture. So here's the central prohibition on torture. Here's the area of permissible conduct. And the idea of this relatively vague and indeterminate language, I thought one way of conceiving of it was that it was primarily just to sort of keep you away from the central core. It was a sort of, don't even go there. Don't even think about approaching. And a lot of law sometimes works like that. Sometimes legal rules allow you to push right up to the edge of the envelope, and as it were, encourage you, like speed limits or tax deductions. But with some other legal norms, it's sometimes inappropriate to push up against the edge of the envelope. If a professor were to say, look, I know I'm not supposed to engage in sexual harassment of my students, but tell me what's the most I can do to a woman student before we want to say, no, you shouldn't even be anywhere near that. You should be well away. And I sometimes thought that the inhuman and degrading standard was performing a similar function with regard to torture. But this present lecture this evening is going to work on the assumption that terms like cruel, inhuman, and degrading actually have integrity of their own, and they have their own work to do, and their own work to do that requires us to think about their specific and distinctive meanings. But if we accept that they have work of their own to do, then we have to ask, how is it appropriate to go about interpreting these provisions? Almost everyone agrees that these standards are contestable. They deploy highly charged value terms, degrading, inhuman, cruel, terms that do tend to be overused in ordinary speech, and many officials, including the former President of the United States, have professed themselves alarmed and determined by the worried by the indeterminacy of this language. This is from former President Bush. What does that mean? Outrages upon human dignity. That's in the Geneva Conventions. That's a statement that's wide open to interpretation. It's so vague, our professionals won't be able to carry forward the program because they don't want to be treated as war criminals. These are decent, honourable citizens, blah, blah, blah. He's suggesting that vague and indeterminate standards are unsatisfactory from the point of view of those professionals who have to somehow make sure they are staying on the right side of these provisions. And although we can make fun of President Bush, you can see what he means, right? These are difficult standards to interpret. Even with the best will in the world, it's not easy to see or to figure out what these prohibitions forbid. Inasmuch as they use evaluative language or value-laden language rather than purely descriptive language, they present themselves, as legal theorists would say, as standards rather than rules. They're not like speed limits, they're more like drive at a reasonable speed. Right? And I believe it's important to keep faith with that fact about them, not to try and prematurely turn these or convert them into rules. It's important to find a reasonable way to elaborate these standards as standards rather than simply convert them into norms that have a different character altogether. So how do we do this? Well, there's a number of strategies we could use. One strategy is simply to throw up your hands and say, as far as possible, we're just going to avoid these provisions altogether. That's what some federal courts in the United States have done when these standards have been invoked in alien tort statute litigation. You probably don't know about the alien tort statute. But in 1790-something, a statute was passed which said the district court shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. Never been abolished. It gives us a sort of a universal jurisdiction. So when one woman one day spotted the Paraguayan torturer of her brother in the streets of New York, she served a writ on him and succeeded in the civil claim under the Alien Torts Act, even though the torture took place in Paraguay against another Paraguayan national, and the action was brought by her under the auspices of the law of nations, which was a general set of standards supposedly applicable in the whole world. It's a little bit of a historic anomaly. It's about as close as the United States gets to the sort of jus togens jurisdiction that some foreign courts have assumed over human rights abuses, the British courts, for example, in the Pinochet case. Now, in a case against not the Paraguayans but some Argentinian miscreants, a district court in California complained about the relativity of the degrading standard. They said this: from our necessarily global perspective, conduct which is humiliating or even grossly humiliating in one cultural context is of no moment in another cultural context. An international tort which appears and disappears as one travels around the world is clearly lacking in that level of common understanding necessary to create universal consensus. Because the Supreme Court of the United States had said, in order to use this provision, the law of nations provision, we had to be appealing to something that was clearly established by a global consensus as being an offence against mankind. Torture, perhaps. But they suggested that the lower standard or the different standard of inhuman and degrading treatment wouldn't meet that. And so there was this insistence on, to be actionable under the Alien Tort Statute, the proposed tort must be characterised by universal consensus in the international community. Piracy, yes. Terrorism, yes. Slaveholding and torture, yes. But maybe not inhuman and degrading treatment, because we don't know what they mean and we don't know whether that consensus exists or not. More recently, some federal judges have been rather more open to arguments under Alien Torts Act. Victor Marrero, who's a judge in the Southern District of New York, once remarked, and I think this was a very honourable remark, that where uncertainty persists by dearth of precedent, declining to render a decision that otherwise might help clarify or enlarge international practice creates a self-fulfilling prophecy and retards the growth of customary international law. And that was a case brought against Zimbabwean authorities by Zimbabwean nationals, claiming that, for example, it was degrading and inhuman to drag the dead body of a political dissident behind a jeep around a village so that the dead man's parents would have to watch this shameful act against this person. So one strategy is to throw up your hands and refuse to deal with it in this spirit. A second strategy is to try to convert it into more familiar language. And the United States has often done this. It entered a reservation when it ratified the International Covenant on Civil and Political Rights, and when it ratified the Convention on Torture, it entered a reservation which says the United States considers itself bound only insofar as the term cruel, inhuman, or degrading treatment or punishment means the cruel, unusual, and inhumane treatment or punishment prohibited by the 5th, 8th, and 14th Amendment of the Constitution of the United States. It's not that this language is necessarily any clearer, it's just that we're more familiar with its unclarity, and we've already evolved some strategies for dealing with it. Notice, however, no such qualification, no such reservation qualifies the American commitments under Common Article 3 of the Geneva Convention, so there's no choice there, but the American courts did and do have to find ways of parsing the language of degradation, dignity, inhumanity, and so on, used in Common Article 3. A third maneuver is kind of try to interpret this quantitatively. There's an author that some of you may have read, a man called Bernard Schlink, author of The Reader. You remember the book and the movie? And he also is a law professor, and he once said, whatever the wording, the distinction between torture and cruel, inhuman, and degrading treatment is simply one of intensity. The idea is that suffering can be more or less intense. Right? At the torture end of the spectrum, you're talking about dreadful suffering. Inhuman treatment, suffering a little less intense, degrading, it's less intense even than that, and then below that threshold, the interrogation practice or whatever it is okay. Right? So the idea is that these are simply different terms used to mark differences of degree in the amount of suffering inflicted on a person. This was used in the European courts, the European Court of Human Rights, in the early stages of its attempting to deal with Article 3 of the European Convention on Human Rights. And it was pretty unsatisfactory. Another way of thinking about it is to see that sort of Venn diagram, that all torture is inhuman and degrading, all inhuman treatment is degrading, but there can be treatment which is just degrading, even though it's not inhuman and not torture. So again, it's the same difference of degree of intensity. And I want to say again, that's not a particularly helpful approach, because these words have meanings of their own, and they look as though they're supposed to mark qualitative differences, not just quantitative differences. Degradation is not just another word for rather less intense pain. Right? Degradation tells you about some specific relation with human dignity. We want to find out what that specific relation is. A fourth strategy, perhaps appealing to the lawyers in the room, would be, okay, well, we take this vague and indeterminate language and we try and convert it into rules. We try to substitute rules for standards. This, I think, is what the European Court of Human Rights has often done with this language. So you take this highly vague, contestable, indeterminate language of inhuman and degrading, and you say, okay, let's put that to one side. We'll try and replace it with a set of practices that we can say are clearly forbidden. So that in one case, for example, you say, well, keeping somebody forever in solitary confinement, that's forbidden under Article 3. And maybe short shackling people, chaining them to the ground is forbidden. And you've decided that in a particular case, so you've now had a norm about short shackling that you can associate with this. And maybe force feeding, except when it's absolutely necessary to save life. And notice what's happening in this rather glib presentation is that the actual provision over here is getting smaller and smaller, and the work done by the precedents is getting larger and larger. No beating in police custody, etc., etc. And eventually what you have is a list of precedents or a list of rules that characterize various practices in relatively descriptive terms, which then supersede this evaluative language over there on the left. As I say, I think that's illustrated in the best developed body of case law on inhuman and degrading treatment, which is from the European Court of Human Rights. Once it abandoned the quantitative approach, its next approach was this reasoned elaboration approach. Through its precedents, it established a set of rules, presumptions, and benchmarks on various issues relating to the circumstances in which it would judge that actions by the authorities of various sorts would violate Article 3. And from a sort of legal practitioner's point of view, it's a good and usable jurisprudence. There may be one or two cases where you think the European courts have been over fastidious. The American administration reacted very strongly against the suggestion in one European case in which prison authorities' failure to recognize a sex change was determined to be inhuman and degrading to the prisoner concerned. And one might also mention a suggestion in another case, not however adopted by the court, that flight paths into Heathrow Airport imposed inhuman treatment on the householders who have to live beneath them. But mostly the court has held firm to its principle that Article 3 should not be cheapened by overuse. But what I miss as this jurisprudence develops is any thoughtfulness about how you reach these precedents. They just simply announce their decision on short shackling or solitary confinement or forced feeding. They just announce that this either is or isn't inhuman and degrading treatment. But there's no particular analysis of why they reached this. I'll give you an example. If you think of some of the cases in which, still disgracefully common in Russia and some of the former states of the Soviet Union and in Turkey, where somebody is made to disappear by the authorities and frenzied inquiries by their loved ones are met by the authorities with indifference and dismissal. So a young man disappears, and month after month his mother and his father go back to the police station or to the local barracks and say, "What's become of my son? If he's dead, tell us. If he's in prison, tell us. If he's being tortured, tell us. At least we need to know." And the European Court of Human Rights has held quite honourably that the refusal to answer these questions is inhuman and degrading treatment. And I guess that's a result that some of us would want. But they just announced that. They just simply suggest that this causes a certain amount of suffering to the mother and father, and that suffering is unacceptable, therefore we're going to prohibit this reaction under Article 3. But I still want to know, how did you reach that? How did you reach that conclusion? I mean, I can construct an argument that given the love and concern that parents would have for even their adult children, it is inhuman to leave them dangling. It imposes a level of suffering that no human should have to endure, to leave them dangling with this uncertainty when you could remedy it. Or it's degrading because it treats their inquiry as though it didn't matter. It treats their inquiry as though it was something that you could simply blow off, as though this person was of no account. And I could imagine arguments of both those sorts, but the court didn't produce those arguments. It simply announced the standard. And it seems to me that although that produces a jurisprudence useful for practitioners, it doesn't offer us much guidance as to how to develop new arguments in new cases. It doesn't offer us much guidance as to how a new judge dealing with a new kind of case should reason their way through to the conclusion that such and such a practice is degrading or such and such a practice is inhuman. So there's a danger that simply allowing the standard over here to be superseded by these rules, it gives us, in some sense, a usable jurisprudence, but it still doesn't give us a particularly thoughtful jurisprudence. Another familiar lawyerly approach to these matters is to try to interpret provisions of this kind by appealing to their purpose. And one danger with that is that it often tends to produce rather bland generalities, and it often tends to reflect the observation of H.L.A. Hart that indeterminacy of purpose is often as much a feature of the laws we make as indeterminacy of the language we use. The open texture or the evaluative character of the language is not the only source of indeterminacy in modern law. Often it's because we're not sure what purpose we are pursuing, or the purpose we are stating is a purpose that we would state only in the most vague and bland generalities. So, for example, in the famous case attempting to abolish the death penalty in the United States in 1972, they suggested that the true purpose lying behind the provision about cruel and unusual punishment is that the punishment must comport with human dignity. Yeah? But that, again, it's substituting a very general, a single general idea as the purpose, which doesn't get you much further in your elaboration. I mean, I don't want to disparage this, but it doesn't get you very much further. Another approach to purpose in these matters, particularly popular where I come from, I mean the United States, not New Zealand, is something like originalism, right? What did the framers have in mind when they laid down these standards? And so, for example, in the United States, when we're dealing with cruel and unusual punishment, we often ask ourselves, what did Madison have in mind, or what did Hamilton or Thomas Jefferson have in mind? They seem to be perfectly comfortable with executions, so they mustn't have had in mind anything that would rule out executions. And if you take that approach, what did the framers have in mind? The self-same language used in the United States, or used in England 100 years before, or used in Canada 200 years later would have different meanings, because the framers would be different people and they would have different mentalities. That's one possible approach. Be that as it may, the originalist approach to cruel, inhuman and degrading treatment, particularly in the international standards, takes us into a dead end. Nobody knows, for example, why the framers of the European Convention on Human Rights omitted the word cruel. Nobody knows whether that was a mistake or whether they had something particular. I mean, no amount of searching in the travaux préparatoires, as far as I'm aware, has explained why they decided to drop the word cruel and just use inhuman and degrading treatment. And we don't get very much guidance from their debates as to what they had in mind. So my view is that we have no real alternative but to focus simply on the ordinary meaning of the words themselves. What do we mean, for example, in ordinary speech, when we tell one another, that was an inhuman way to behave? Or when we say to one another, that was a degrading way to treat her? If we just simply try to focus qualitatively on what these words mean, on the meanings that they have established in our civilization, then the one thing we know about the framers is that they chose to use those words, presumably with those resonances, allowing for translation. They chose to use those words with those resonances. So the first, maybe not the last port of call, but the first port of call in our elaboration of these standards should be to focus on what the words mean in ordinary life. Now, even that is controversial, and lawyers these days are very disparaging of approaches to interpretation that involve going back to the dictionary. And you will find an alarming amount of dictionary work in what's going to follow. In Matlanyane, which is the great death penalty case from South Africa, the very beginning of the work of the South African Constitutional Court, Arthur Chaskelson said this in his judgment: in the ordinary meaning of the words, the death sentence is undoubtedly a cruel punishment. It is also an inhuman punishment, and it is degrading. He had no doubt that that was true in terms of the ordinary language meanings of those words. But then he added this: the question is not, however, whether the death sentence is cruel, inhuman, or degrading in the ordinary meaning of those words, but whether it is a cruel, inhuman, or degrading punishment within the meaning of Section 11.2 of our Constitution. Saying, in other words, that these might have a technical meaning in law. But here's the thing. This was damn near the first case in which the meaning of those words in Article 11.2 of the South African Constitution was being determined, and so we're back to the same old difficulty. How do we get to establishing, how do we go about establishing the meaning these words are to have in our Constitution? We can't just assume that it is that it exists as a legal technicality already, because this was before there had been any hard work done on the matter. So what was to guide President Chatstelson and his fellow justices on the South African Constitutional Court as they tried to figure out what inhuman, cruel and degrading meant in the constitutional context that they were addressing? So, I propose we go to the language itself, and I want to approach the language, particularly of inhuman and degrading treatment or punishment, with 5 general propositions in mind. The first is that value language is worth unpacking. Value language, words like inhuman, degrading, cruel, are complex evaluative ideas. And it is worth taking apart those complexities to see what sense we can make of them. I take it there are some philosophers here, and some of you may know the work of Philippa Foot in the 1960s and 70s. And Philippa Foot, one of the things that she did was to take concepts like calm and courage and pride and take these terms apart, not trying to convert them from evaluative into descriptive, but to tease out the various strands of evaluation that they might involve. When we are talking about inhuman and degrading, those are negative evaluations of a thick kind rather than a thin kind. They are not just synonyms for bad. Right? They're not just synonyms for bad. They tell us about a particular sort of badness, and we want to tease out the content of that. They are particular, not all-purpose evaluations. They're not just synonyms for undesirable treatment. Right? They give you an evaluative reason for saying the treatment is undesirable. We are invited to look for a particular sort of badness, a particular sort of undesirability, and it's the purpose of the word meanings of cruel and inhuman and degrading to indicate to us what that particular sort of badness is supposed to be. We should concentrate, thirdly, on a sort of via negativa, the path not chosen, the words that have not been used. These provisions don't forbid unjust punishment, or inefficient punishment, or pointless punishment. They don't use those words, although connections might be thrown across to those words in detailed doctrinal elaboration. Our evaluative language is very rich, and these provisions draw on some of these riches and not others. And we should focus on that. So what is particular about degradation? Somebody's taken the care to choose that word rather than every other synonym for undesirable. Let's focus on the contrast between that word and the path that was not taken. Fourthly, I mean, these are all ways of saying the same thing. Different terms mean different things. I assume that the use of more than one term, inhuman and degrading, indicates 2 standards, not one. Indicates 2 standards, not one. The United Nations Human Rights Committee is on record as saying that it is not necessary to establish sharp distinctions between the different kinds of punishment or treatment, but I'm not going to follow them on that. I think we should at least begin with the assumption that 2 quite different words, like inhuman and degrading, are supposed to convey 2 quite different evaluative meanings. And the final point is to respect the categorical logic of the provisions in which these terms find themselves. Treatment which is inhuman and degrading in these provisions is prohibited whatever else it is. Suppose it's ordained by God. The logic of these provisions is that doesn't matter if it's inhuman and degrading. If God has decided to impose inhuman and degrading treatment, that is still prohibited by law. Suppose these forms of treatment or punishment are thought to be necessary for national security. Again, it doesn't matter. The syllogistic logic of these provisions is if they are inhuman and degrading, they are forbidden, whether they're necessary for national security or not. Now let me just elaborate that just a little bit. In some of the European jurisprudence about the use of chains and shackles, the court has sometimes said, the European Court of Human Rights has sometimes said, that the use of shackles is prohibited by Article 3 of the Convention unless it is necessary to prevent harm to the other people in the courtroom or other people in the cell block or whatever. So it looks as though they use a criterion of necessity to moderate this. And you might say, well, if you can use necessity in that way, why can't you use it, say, in the ticking bomb circumstance, to say that the degrading treatment was necessary to save hundreds of lives? Here's the answer. Somebody is shackled, chained up, and he says, why am I being shackled? And you say to him, because we have a reasonable belief that you might harm other people, and that it's necessary to prevent that harm. It seems to me that giving that response dispels the appearance that the shackling is degrading. He's no longer just being treated arbitrarily like an animal. He's being treated for certain reasons that make it necessary to shackle him. So the appearance of degradation, as it were, evaporates once the explanation has been given. In the ticking bomb case, when we decide that it's necessary to interrogate somebody in a degrading manner, what we often decide in those cases is it is necessary to degrade them in order to get this information. The degradation itself is precisely what is necessary. And that, it seems to me, is prohibited in these provisions. Yeah. We admit that it's degradation. If this didn't degrade him, we'd have to try something else to degrade him in order to try and humiliate him sufficiently to get the information out. So the degradation figures in our strategy, whereas in the other case, the appearance of degradation is dispelled by the strategy. Okay, well, enough in the way of generalities. I'm not going to talk much about cruelty, although I will be happy to answer some questions about the discussion, but I really want to begin now and just say a little bit about inhuman and degrading, these two separate provisions. So let's begin with inhuman. First thing to notice about inhuman is that it doesn't mean the same as inhumane. Quoted my favourite Chief Justice on this matter from New Zealand, Sean Elias, suggesting that there's a contrast between inhuman and inhumane. The Oxford Dictionary tells us that none of the 19th century dictionaries until quite recently actually recorded inhumane. We conclude that inhumane in current use has been formed afresh on humane in order to provide an exact negative to the latter, and thus it's a word of milder meaning than inhuman. What that kind of conveys is that if you're thinking about the range of treatment that's prohibited by a prohibition on inhumane treatment, the range of prohibited behaviour will be quite large. If you think of the behaviour prohibited by inhuman treatment, which is a much narrower, more focused term, it would be quite small. Or to put it the other way around, to be guilty of inhuman treatment is to be guilty of something much worse than simply inhumane treatment. And it was noticeable in the United States during the torture debates that whenever anybody wanted to disparage the standard prohibiting inhuman treatment, they would substitute the word inhumane, as though they were being held to this higher standard of requiring us to treat the Al-Qaeda guys humanely, rather than requiring us to observe this very, very elemental standard. The term inhuman seems to refer to the absence of something to do with our common humanity, or the presence of something at odds with it. There's something about being human that makes particularly problematic either the behaviour so far as the agent is concerned, or the impact of the treatment so far as the victim is concerned. So we might say that the torturer was behaving inhumanly, or we might say that the victim was suffering inhumanly. The term can be used in either direction. The dictionary seems to favour the first. According to the Oxford English Dictionary, inhuman, as applied to persons, means not having the qualities proper or natural to a human being, especially being destitute of natural kindness or pity, being brutal, unfeeling, and this other word, cruel. It's a person meting out the treatment who is inhuman, who doesn't have the qualities proper or natural to a human being. The term is a vice word. It picks out the vice as David Hume would have it, of inhumanity. There was a British judge called Judge Fitzmaurice in his separate opinion in the European Court on British maltreatment of detainees in Northern Ireland in the 1970s, and he said that the concept of inhuman treatment should be confined to kinds of treatment that no member of the human species ought to inflict on another, or could so inflict without doing grave violence to the human as opposed to the animal element in his or her makeup, and the his or her is the person who is doing the inflicting. So it's an agent-oriented standard, although it's an agent-oriented standard having to do with the inhumanity of somebody who treats humans in a certain way, as opposed to the inhumanity of somebody who treats dogs and cats, for example, in a certain way. I guess the idea is that there is a natural empathy among humans, and somebody becomes inhuman in themselves when they are able to act in a way that overrides that natural empathy. Now, we know that there are torturers who derive pleasure from torturing their fellow human beings, and so and if we want to say that nevertheless they're doing grave violence to the human as opposed to the animal element in their own makeup, that we have to regard that as some sort of pathology, acknowledging that it is sometimes done perfectly cheerfully and the person is able to carry on functioning. So there are some antinomies with regard to using inhuman patient to the agent in question. If we move over to use inhuman with regard to the victim, we might want to develop a notion of inhuman suffering, phrase used by Milton in Paradise Lost. Suffering that no human could reasonably be expected to put up with. Something like that. And maybe that's what's prohibited, because in these provisions. Something might be described as inhuman if it were thought that no human should or could or should have to put up with it, rather than inhuman because, on the other side, that no human could or should be able to inflict it. It's a different sort of invocation of our human qualities. It looks to the limitations of our ability to endure certain things. But again, it's not easy to parse that. Over here, we had to deal with a person who, while he might have done violence to the human element in his makeup, seems to be able to function perfectly cheerfully and perfectly well. Over here, we want to ask, well, what exactly is supposed to happen when this treatment is inflicted in order to show that the person couldn't reasonably be expected to put up with it? Is it that they black out, or cease to function, or die if they try to endure it? What happens? Death, physical collapse, madness, what? We may say that the human capacity for bearing pain is limited, but what are we saying will happen? What are we predicting will happen if that threshold is exceeded? Obviously, there's some sort of normative claim here, some sort of claim about what a human could reasonably be expected to put up with. And I think there's a normative claim here about grave violence to human nature of the perpetrator as well. But it's interesting, we're still making progress, even though we've substituted one normative, one contestable, indeterminate normative idea for another, because we're not simply using this as an all-purpose evaluation either. We're trying to think a little bit about what the limits of human endurance are. I've often thought it's a very important part of our theory of punishment, if punishment is to be consistent with human dignity, that punishment must in a sense be bearable. It must be something that a person can perform or endure without giving up their human dignity. Even if it's incarceration, goodness me, even if it's execution, punishment ought to be something that a human, a man or a woman, can, with dignity, even though there's a stigma with punishment, nevertheless it ought to be a form of treatment that a person can, in some sense, endure. And I think some idea such as this is at play in these provisions. Is it just about the infliction of suffering? I'm not sure. I think we might also want to think about impositions on people that are indifferent to the needs and rhythms of basic human life. Think of the needs and rhythms of our life. Sometime in the next 6 or 7 hours we will all go to sleep. Yeah? Because it's part of human life that you have to sleep every day. And before we go to sleep we'll all go to the bathroom. It's part of human life that you have to urinate regularly and defecate every day and so on. And these needs and rhythms of human life are well known to torturers. And disrupting them, frustrating them, or interfering with people's ability to take care of them in an ordinary human way is a strategy well known to torturers. And so quite apart from any particular suffering there, you might want to think about the humanity standard as requiring sensitivity, even in extremis, even in detention, to the basic rhythms and structures of human life. Remembering particularly the context in which these standards are supposed to be operating. They're supposed to be operating in situations like detention, incarceration, and so on, where people's living conditions are totally at the mercy of others. People are in total institutions, and it's virtually every movement of theirs may be supervised. There's much, much more to say about Inhuman, but I wanted to move on and say something about degrading. Now, degrading might be thought to have the same agent-victim duality. The torturer degrades himself, the torturer degrades the victim. Yeah? And I believe mostly it is a victim-oriented term. It's a victim impact term, if you like. The Oxford Dictionary defines degrade rather formalistically as meaning to reduce from a higher to a lower rank, to dispose from a position of honour or estimation. Somebody is degraded if he's treated in a way that corresponds to a lower rank than he actually has, treating the Queen like an ordinary woman, or a professor like an ordinary graduate student. Those of you who are old enough to have watched this movie will remember The Bridge on the River Kwai, David Lean movie starring Alec Guinness as Colonel Nicholson, the officer in charge of a large brigade of English soldiers who fell into the hands of the Japanese. And Colonel Nicholson insisted to the Japanese commander of the prisoner of war camp that he and his officers are exempt by the laws of war from manual labour, even though the private soldiers under his command might legitimately be forced to work. He had his own copy of the Geneva Conventions. Nicholson clearly believes that forcing the officers to work would be degrading to them as officers, and he suffers a great deal as a result of the Japanese reaction to his refusal to accept this degrading treatment. However, it's pretty clear, I think, that when we use the notion of degrading treatment, we're not so much sensitive to these distinctions of rank that we might observe in other circumstances. We have an idea that there's a basic rank or dignity that all human beings have, which is to be upheld. We have, as it were, democratized the idea of rank or dignity. I gave some lectures, the Tanner lectures at Berkeley in April, where I argued along lines suggested by Gregory Vlastos and James Whitman and others, that although we used to have a hierarchical notion of dignity, where the dignity of a professor was different from the dignity of a student, now we have a notion of equal human dignity. And it's still a notion of high rank, it's just now a high rank assigned to all of us. Every man a king, every woman a duchess, every child a prince. And treating people, it's a democratic notion, but it's a high-level democratic notion. And so degradation means treating some humans as though they had a lower rank than the same very high rank that all humans have. I mean, you can give a religious account of that high rank. We are created just a little lower than the angels. You can give a religious account of it. We are created at the high rank of bearing the image of God. Or you can give a Kantian account of it in terms of the high rank conferred on us uniquely among animals by our moral capacities. But the idea is that humans as such have high rank, and to treat somebody in a way that is incompatible with that is what degradation amounts to. Avishai Margalit is an Israeli political theorist and a very profound writer, and in his book on the Decent Society, in the section on humiliation, he suggested that there were 4 modes of degradation that we might want to pay attention to. The higher than the animal sense of human dignity gives us a natural sense of degrading treatment. It is treatment that is more fit for an animal than a human. Treatment of a person as though he were an animal, as though the things that distinguish humans from animals didn't matter in that person's case. Treatment that is insufficiently sensitive to those differences. Treatment insufficiently sensitive to the differences in virtue which humans are supposed to have special status. So, for example, a human is degraded by being bred like an animal, or used as a beast of burden, or beaten like an animal, or herded like an animal. Sometimes in the United States, in courtrooms, they use cattle prods. to bring defendants into the courtrooms. It might also include cases of post-mortem ill treatment, like that Zimbabwean case that I mentioned before. Failing to properly bury a human is degrading to the human being whose corpse it is, and inhuman to the relatives who have to watch the spectacle. A second mode of degradation is instrumentalization, treating a human simply as an instrument. We exploit animals as though they were mere means, objects to be manipulated for our purposes. And this can generate a broader sense of degrading treatment associated with the Kantian meaning of dignity, being used as a mere means, being used in a way that is not sufficiently respectful of humanity as an end in itself. And those of you who have taken philosophy will know how important that idea is in Kantian ethics. This sense of degradation may be particularly important, I suspect, with regard to sexual abuse. A third kind of degradation may have to do with the special dignity associated not with humanity as such, but with human adulthood. An adult has achieved full human status and is capable of standing upright in her or his own account in a way that, say, an infant is not. So it is degrading to treat an adult human as though he or she were an infant, or in ways appropriate to treating an infant. That's particularly important with regard to some of those rhythms of human life that I spoke about before. Elementary issues about care of self. Part of the dignity of being an adult human is that you can take care of self in self-presentation. A number of the European cases have dealt with treatment that involves people being, quote, forced to relieve bodily functions in their own clothing by the police. And we Americans, those of us south of the border know to our shame that this was an issue in some recent forms of mistreatment of US detainees as well. And again, remember the context, that we are dealing with people whose life circumstances and self-presentation is totally at the mercy of the authorities who are holding them. The final mode of degradation that Marguerite talks about is demonization. The prohibition on inhuman and degrading treatment has particular importance in the way we treat our enemies, or terrorists, or the worst of the worst among criminals, those whom we have most reason to fear and despise. And obviously one of the functions of the degrading treatment standard is to limit the extent to which we can treat somebody who is bad or hostile as though he were nothing but an embodiment of evil. There are special prohibitions in the Geneva Conventions against putting prisoners on display. And I would also mention in this connection the ancient biblical injunction in Deuteronomy on the number of stripes that may be used if somebody is sentenced to be beaten. 40 stripes may be given him, but not more, lest your brother be degraded in your sight, so that his humanity should not simply become a spectacle of degradation. There's a wonderful old Talmudic story called the story of the twin brothers. And it's relevant to conceptions of dignity that are religious in the sense of related to humans being created in the image of God. Twin brothers, one of them became a king, one of them became a bandit. And the bandit was apprehended and hanged, and his body was left dangling for days from the tree on which he was hanged. And everybody walked around and looked at him and said, "The king has been hanged. The king has been hanged." He bore the image of his brother. And that was a reason for the insistence that even if there is going to be capital punishment, there has to be reverent treatment of the body has to be taken down historically, because otherwise we are treating something human as though it were merely a demon, and therefore demonizing even the element of the divine in all human beings. In a 2005 decision of the Supreme Court of Israel, dealing with what we call in the trade targeted assassination of terrorists. This is where you take somebody who's a terrorist on Mondays, Wednesdays and Fridays, but works in his garage in Ramallah on Tuesdays and Thursdays and Saturdays, and you attack him or seek to kill him when he's not actually engaged in terrorist activities. And this is a difficult issue, and it was a well thought out and nuanced decision. But at the very beginning of his opinion, President Emeritus Barak of the Israeli Supreme Court said, "Needless to say, unlawful combatants are not beyond the law. They are not outlaws. They are not demons. God created them as well in his image. Their human dignity is to be honoured as well." It was just it didn't mean that targeted assassination was prohibited, but it affected the issue of how lightly or carelessly we could take this question of taking away a human's life. So there's the suggestion that even when you're confident that you're dealing with somebody who is a threat or an enemy, you must nevertheless still respect the humanity in that person and not degrade them below the level of human remains, I think, very, very important. There is more to say about degradation, but I need to sort of move towards a conclusion here. There's tons more to say about all of this, and I'm happy to talk more about it in discussion. But I want finally to reflect a little bit on what we have been doing in this analysis. I have said that it's very important when you're dealing with these terms to keep faith with the fact that they are value judgments. Not be panicked by that. Not shy away from it. In my experience, some law professors have a tendency to teach their students that legal standards that require them to make value judgments are always to be abhorred and replaced as quickly as possible by legal norms that don't require them to make value judgments. And the trouble is that draws a line between law and thoughtfulness, which I think is very, very important. It's mostly thoughtfulness about these standards that I've been trying to drive home this evening. So, I'm a follower of Ronald Dworkin, my colleague, mentor, and at NYU. And he insists that when you have value language used in the Charter or in the Constitution, whether it's the language of reasonable or unreasonable, whether it's the language of excessive bail or excessive fines, whether it's the language of cruel and unusual punishment, or whether it's the language of inhuman and degrading treatment, we should treat those provisions as instructions to us to make the best value judgment of the kind that the words indicate to us that we can. To make the best value judgment that we can. Not shy away from the value judgment. It's as though the law says, you are not to inflict punishment which is make value judgment here. Right? Not any old value judgment, but the value judgment indicated by the word cruel, or the value judgment indicated by the word inhuman. And not just whatever comes into your head, but the most scrupulously objective effort you can make at trying to figure out what would be appropriate under those headings. And I believe generally that strategy, which he calls the moral reading of the US Constitution, but it could equally be the moral reading of the Charter, is an important strategy for promoting legal thoughtfulness, as opposed to trying to cut off thoughtfulness and treating our science and our discipline as though we were just a trade school. But having said that, there is something else to be said about these standards that I've been talking about, inhuman and degrading treatment. I think that they were not just instructing us in our solitary quest for objective value, each of us as judge or advocate, to make the best value judgment that I can, or that Grant can, or Margaret can, but to try to hook up with some value judgments that the framers of these provisions assumed existed in the world at large. I think when words like inhuman and degrading were used, there was an appeal to certain standards that existed in the world, among the peoples of the world, in the moral communities of the world. There was a suggestion that this is not just requiring each of us to be Immanuel Kant or Socrates, but each of us to put out our value antenna a little bit and see within the context of our civilization whether we had evolved and begun to share standards of the dignity appropriate to a human being and the wrongness of degradation relative to that, to see whether we in the world had begun to use an idea of humanity and inhumanity in our dealings with each other. I think it's an appeal to a standard that is shared in the world. It may have been an over-optimistic appeal, And we remember that sometimes the standards that are used may vary from culture to culture. And you remember that American court I mentioned under the Alien Torts Act was worried that the standards for degradation differ from one community to another, which I thought was a thoughtless comment. It's like saying the standards for religious toleration differ from one community to another depending on what the dominant religion is. Yeah? You can still have a general universal prohibition on degradation. For example, you could have a universal prohibition that it's always wrong to force a woman to violate her own standards of modesty, even though you acknowledge that the standards of modesty might differ from community to community. That's a universal standard interpreted indexically. It's not a concession to moral relativism. So I believe in every culture, for example, it's degrading to be forced to violate one's own deeply held principles of modesty. The principles may vary from setting to setting, but the standard which prohibits this form of degradation remains the same. Right? So tearing off the headscarf of one woman might be as much of a violation as tearing off the miniskirt of another woman, right? Different standard of clothing, different standard of dress, different cultural or religious prohibition. But the effort at degradation would be the same, and the prohibition on degradation would be the same, even though it required, rather than attenuated, sensitivity to context. I believe also that of the 164 nations that signed and ratified the International Covenant on Human Rights, they all developed within their cultures ideas about how it was appropriate to treat humans as such. They may not all have developed the same ideas about how it was appropriate to treat humans as such. But people didn't just develop, the New Zealanders didn't just sign it thinking that there were ways that it was wrong to treat New Zealanders, and the Australians thinking that there are ways it's wrong to treat the Australians. Every distinct culture has the category human, and has a category of the special dignity of humanity. And I believe that there was an appeal to try to unite those different forms of dignity. I believe most cultures see the value of some convergence between them on acknowledgement of minimal standards in this area. So I think we should keep all of this in mind as we parse out these ideas and not immediately panic at the prospect of relativism. I believe that these standards are part of what we have as a common heritage. In the United States, we found, to our cost and shame in 2002 to 2008, that a commitment to some of the standards like Article 7 of the International Covenant on Civil and Political Rights or Common Article 3 of the Geneva Convention actually committed us to privileging some elements over other elements in our sense of ourselves. Americans, south of the border, as you know, like to swagger around and blow things up. We like TV shows in which the hero breaks people's arms in order to elicit vital information. But our culture is also riddled with, pervaded by, universalistic, humanitarian and dignitarian ideas about the proper and respectful treatment due to every human being. That's part of American culture and civilization, as it is part of every culture and civilization. Our commitment to these conventions requires us to privilege the latter over the former. It's not a matter of submitting to funny foreign Canadian standards. It's about privileging some of our own standards and you privileging some of your standards in this common enterprise of perhaps seeing the value of some convergence in minimal standards in this regard. So that's a sort of the general philosophical approach that I wanted to take. Most of all, I wanted to leave you with a sense this evening that simply by staring at and concentrating on the words themselves, with these terms cruel, inhuman and degrading, you can begin to attain the sort of thoughtfulness about the treatment of human beings by each other that I think the framers of these documents had in mind to inculcate in the legal and political world. Thank you very much indeed.